Hello, my name is Jodee Dietzenbach, and I'm an attorney with Pioneer Law Office. This is the final video in our multi-part series on how to apply for Social Security disability benefits. So here is what happens after you file a claim. First of all, when you file your initial application, that is what we showed you how to do in the first two videos. You file your application online or by telephone. You can expect to have to provide medical records and complete multiple forms. Social Security is going to be asking for a lot of information about your health conditions, about the types of medications that you take, about the doctors that you see, the types of testing that you've had done. They are also going to be asking about things like your job history, what types of work you've done in the last 15 years. And a lot of times they will request specific documents from you so they can verify some of that information, like your birth certificate. But really, it depends on the case and what Social Security has to review. So in this case, reviewing an initial application can take generally between 3 and 6 months. And that's going to mainly depend on whether they have to request medical records. They're not going to make a decision until they have all those records to review. Sometimes Social Security will send the claimant out for additional testing or an examination by an actual doctor. So if you get denied on initial application, you have a right to appeal. Instructions for the appeal will be in your decision. You have 60 days plus 5 days for the mail to request reconsideration online or in writing. When you request a reconsideration, basically you're asking for Social Security to review your case again and look at some things, some situations or circumstances that have changed. Either you have submitted new evidence, your condition has gotten worse or changed somehow, you have a new diagnosis, you have new medications. A lot of times when you're at the reconsideration stage, Social Security will update your medical records again. The other thing they can do is send you out for an evaluation. And that evaluation is called a consultative exam. And you will go to your appointment. You'll provide all the necessary things that they told you to bring with you. Usually it's a photo ID of some kind, so you can prove who you are. And then a doctor will examine you. It can take about 3 to 6 months. This varies a lot more than, say, the initial application time period. Generally, they're looking at, it's going to take longer if they have to send you out for 2 examinations, one for mental health, one for physical health. Or if they need to do specific tests like a pulmonary function test or hearing tests, vision tests, those kinds of things. The more things like that they have to complete, the longer that's going to take. And then once they have all that evidence gathered, they have a doctor review it all. And doctors will write some opinions in the file about how they think you're restricted. And then they will make a determination as to whether or not you meet the qualifications for Social Security disability. If you get denied at that point, then you can request a hearing. Requesting a hearing involves filing another appeal. Instructions for the appeal will be in your decision. And again, you have 60 days plus 5 days for the mail to request a hearing online or in writing. Once you request a hearing, you will have to wait for an administrative law judge to become available to hear your case. This can take time. You are responsible for notifying Social Security about updating medical records. You want to make sure that you are getting your own medical records or calling Social Security and letting them know that you want them to get your medical records. If you have an attorney, your attorney will help you get medical records and will help you decide when to request medical records, which can be important because if you're getting your own medical records, a lot of times your healthcare provider will charge for those. So one value to having an attorney is we typically know how long it's going to take to get a hearing in our area. And we'll be able to help you decide when is the best time to request your records. So that will save you money in medical records and still make sure that Social Security has everything they need in time for the hearing. Hearing wait times vary greatly across the country. Generally, you should expect to wait 9 to 14 months from when you request a hearing until you get one. So I've seen my wait times in my area go from between 12 and 24 months. I had a couple of hearings that the claimants had waited almost 2 years for a hearing because that particular hearing office was just so far behind and they didn't have as many judges there compared to the amount of cases they had. So those wait times have gone down now, and I've seen it closer to 6 to 9 months out of some hearing offices and 9 to 12 months out of others, depending on which hearing office it is. So be aware that you're generally going to have to wait a while. They will give you 75 days notice. So they will notify you by mail generally 75 days before your hearing is scheduled. So you should still have time to get updated medical records and get ready and get your transportation ready if necessary, or arrange to be able to do your hearing by phone or by video teleconference. They're trying to get everybody scheduled quickly and efficiently and use the judge's time efficiently as well. So once you get a hearing scheduled, you'll want to get all of your medical records updated. You will want to prepare for your hearing. At your hearing, you will attend a hearing with the judge. The judge will ask you questions about your case. And after your hearing, you will have to wait for the judge to write your decision. Social Security will send the decision to you in the mail. It is a non-adversarial hearing, which means there's no attorney for Social Security trying to prove that you shouldn't get benefits. There's just you and the judge and the experts and your attorney if you choose to hire one. So it makes it more of a question and answer session instead of the types of court proceedings that you may have seen on TV. The other thing is you won't get a decision that day, the day of your hearing. Typically, the judge may give you some hints or may actually say to you, I'm going to approve your case, but nothing is official until you get it in writing. So you will get some type of written decision in the mail. And every judge is a little bit different in how long it takes them to get those decisions out. Again, it varies by judge and it varies by hearing office. So it really just depends on how long it takes them to go over all of your information. Those decisions are generally 20 pages long or more because they have to talk about all the evidence that they considered and all the law that they reviewed. So it's generally not going to be just a 1 or 2 page thing, and it does take them time to write it. If you get denied at the hearing level, you can request review with the appeals counsel. You have 60 days plus 5 days for the mail to request review online or in writing. And the appeals counsel will review evidence in your file and consider legal arguments. Generally, they are not going to consider any new evidence unless it relates back to the time period before the judge heard your case. Generally, the appeals counsel review can take 6 to 12 months. If they decide not to review your case, the decision of the judge that did your hearing stands as the final decision in your case. If the appeals counsel finds that the judge has made mistakes, they can do there's 2 main things that they do. The first is that they can reverse for the payment of benefits, meaning they disagree and there's more than enough evidence to prove disability in your file, thus there's no reason for any additional procedures. I can tell you this does not happen very often. Most of the time, if we win an appeal at the appeals council, it's because the appeals council orders a remand. And what a remand is that the appeals council sends your case back to the judge that did your hearing and says, these are the mistakes that we think you made, and this is how we think you should correct those mistakes. Generally, when the appeals council orders a remand, they're going to ask for the judge to do a new hearing and to update all the evidence in your case. So if that's the case, then you go from the appeals council back up to do another hearing again. So it's kind of like you loop it around, and then you do a hearing, the judge does a new decision. And then, if you don't agree with that decision, you can go back to the appeals council. Once you have gotten a denial at the appeals council, that's the last step of the appeal process within Social Security, but you can still sue Social Security in federal district court if you get denied at the appeals council. So what happens when you get to the end of the Social Security appeals process? Well, that depends on your claim. You may be able to go back and file a new claim, go all the way back to the beginning, file an initial application again. If you file an initial application, generally it's not going to be for the same time period as your last claim. So generally it's not for the same time period. There are some exceptions to that, but they're very rare. And so then you would start a new claim and you would go through this whole process again. Sometimes you can't file a new initial application depending on what type of claim you have, but generally that's kind of it from start to finish. This is going to be the end of our series on how to file a Social Security disability claim, although I will be doing some more videos, kind of going through, maybe filling in some gaps, doing some more short videos on smaller subjects, and maybe doing some on some different areas of law like VA disability, or other types of Social Security claims like children's claims or supplemental security income claims. If you want help with your Social Security claim or with your veterans disability claim, please give me a call. My name is Jodee Dietzenbach, and I'm an attorney at Pioneer Law Office. And I'll put my information down below, and it'll also be in the description. So thank you very much for watching, and stay tuned. We'll have more videos soon. And if you need any help, give me a call, 563-583-9101. Thanks.